Good morning, everyone. Uh, Hi, this is Shivani, and today we're going to be talking about the doctrine of harmonious construction in the interpretation of statutes. So, what is the doctrine of harmonious construction? First of all, the Parliament makes separate set of rules, legislations, and regulations, as well as various constitutional provisions, and then gives them a set of defined rules. So while framing these provisions, one has to be very careful about the conflict that may occur because of certain provisions overlapping with each other. In that case, there are chances of certain gaps being left while framing these provisions, which could not have been foreseen by the legislatures while they were making those laws. To deal with such conflicts, certain doctrines and rules are propounded by the court that are used in interpretation of statutes. One of such rule of interpretation is the doctrine of harmonious construction in the Constitution of India. What do we understand by this term, the harmonious construction? The doctrine of harmonious construction, it is considered as a thumb rule in the interpretation of statutes. What does this doctrine say? The doctrine states that whenever there is a case of conflict between two or more statutes or between two or more parts of a provision of a statute, then such a statute has to be interpreted upon harmonious construction. It signifies that in the case of inconsistency, proper harmonization is to be done between the conflicting parts so that one part does not defeat the purpose of and the second part. This particular doctrine is based upon one cardinal principle in law that every statute has to be formulated with a specific purpose and intention and thereby should be read as a whole. Now, the general presumption is that what the parliament has given by on one hand is not to be taken away by the other. So, whatever the parliament gives cannot be taken away for another purposes. The essence is to give effect to both the provisions, that is, like both the provisions which are in conflict with each other. Now, to avoid this conflict, the adopted interpretation of the statute should be consistent with all the provisions. So therefore, there seems wherever it seems like there's an impossibility to harmonious construe or reconcile certain parts of provisions that are inconsistent with each other, then the matter rests with the judiciary. In such a case, the power to decide which legislature foregoes the other legislature, which legislature supersedes one legislature, is with the judiciary. The aim of the court is to do the interpretation in a manner that resolves the repugnancy between both the provisions and then enables the statutes to become consistent as a whole so that it can be read accordingly. Now, how did this doctrine of harmonious construction actually originate? We can say that the doctrine of harmonious construction was established as a result of interpretation of various cases. Which are these cases? One of the landmark cases that came into being was Sri Shankar Prasad Singh versus Union of India in the year 1951. In this, there was a disagreement between the part 3, that is the fundamental rights, and part 4, that is the directive principles of state policy of the Constitution of India, which was the subject of that case. The court then used harmonious construction to rule that fundamental rights, which are guaranteed as against the state, may be revoked under certain circumstances and modified by the parliament to bring into compliance with certain other constitutional provisions. Both of these were given preference, and it was determined that fundamental rights and directive principles of state policy, these are just two sides of the same coin that must be worked together to provide greater good. The theory was then developed historically through law of conciliation, which was first proposed in the C.C. Birard General Clauses Act of 1914. This court then used rule of interpretation to prevent any overlap or confusion between entries 24 and 25 of the state list to read them in a logical manner to determine the scope of the subjects in question. The principles of there are five main principles which are present under the doctrine of harmonious construction. So according to the doctrine of harmonious construction, basically a statute should be read as a whole, and one of the provisions of the act should be construed with the other provisions of the act so that it becomes consistent with the entire enactment of the act for its purpose. Such an interpretation, it is beneficial so that there could be any repugnancy or inconsistency present which could be avoided in the foreseeable future. Now, there are 5 main principles of the rule. First is the courts must avoid head-on clash seemingly contradicting provisions. That they must construe the provisions contradictory and so as to harmonize them. If there are any provisions which are contradictory to each other, totally different, the courts must make sure that it enters upon a consensus, and based on that consensus, the provision should be harmoniously construed so that the faith and substance of the act that was in question could be taken into consideration. We have already learned about faith and substance in the previous videos. The provision of second one is the provision of the one section. It cannot be used to defeat the provisions contained in the other section unless the court, despite all of its effort, is unable to find like a medium ground so that it could be harmoniously construed. Where one section oversees or supersedes the other section, the court tries its best to harmoniously construe those provisions. But in case it cannot be done, if there is an impossibility of harmonious construction, then the provision which is of more importance supersedes the one which is of less importance. Third one, when it is impossible to reconcile the differences between contradictory provisions, then the court must interpret them in such a way so that the effect is given to both the principles as much as possible. If the interpretation is done in a manner where it is completely impossible to harmoniously construct them, effect must be given in such a manner that both the principal provisions are taken into consideration. However, again, the court must also keep in mind, which is the fourth point, that the interpretation that reduces one provision to a useless number or dead number is not a harmonious construction. The court must try its best to make sure that the second provision also comes into picture. However, when that is not possible, this would not amount to harmonious construction. Fifth point, to harmonize is not to destroy the statutory provision or to render it fruitless. So basically, it means to harmonize is to bring both the provisions into picture simultaneously or with each other in such a manner that neither of the provisions supersedes the other. Then various cases had come into picture regarding this. Many in this doctrine was then interpreted to various cases that came into other forms. How is this? So this brings us to our next question: how is this doctrine of harmonious construction applicable, and what is the applicability of this statement of this doctrine? The courts have formulated some measures for the improved applicability of the said doctrine of harmonious construction after viewing numerous cases, like I said. So there are certain important cases like Venkatramana Devru versus State of Mysore and others. It was in the year 1958 where court applied harmonious constructions between Articles 25 2B and Articles 26B of Constitution of India. This is related to religious denomination. And according to these, this being one of the landmark cases, had also given rise to certain applicability or improvement in the doctrine of harmonious construction. So what does the applicability of harmonious construction include? First is giving maximum force to both clauses, thus reducing their inconsistency or dispute. Second is both clauses that are inherently contradictory or repugnant to one another must be read as a whole, and the entire enactment must be considered. Third is to choose the one with a broader reach of the two contrasting clauses. The one which has a broader reach, the one which has more important, more specific, should be considered above the other that is less important or less specific. Compare the broad and narrow provisions, then try to analyze the broad law to see if there are any other consequences. Obviously, no further investigation is needed if the result is fair as harmonizing both the clauses and giving them full force separately. But one thing that has to be kept in the mind is that the legislature, when enacting the provisions, was well aware of the situation that they were attempting to address, and thus all provisions adopted must be given full attempt to increase its scope or to widen its scope up to the extent that the legislature demanded it to be. Then comes a non-obstant clause. Non-obstant clause is a clause that starts with notwithstanding, therefore, or something along those lines. Any clause must be used with one provision of an act that strips away the powers conferred by another act. It is very important to note that the court has to determine the degree to which the legislature wanted to grant one clause, overriding the authority of the other. In a very landmark case, another landmark case, which was Eastbourne Corporation versus Fortis Limited, it was decided that two opposing sections could not be reconciled. The last section would take precedence. This isn't a universal law, but it was something that was followed or practiced or stated that if the two opposing sections could not be reconciled, then the last section would take precedence over the first section. So this is what the doctrine of harmonious construction states. Therefore, judiciary in this age, it is an independent body which acts as a supreme source of justice to the people. So in conclusion, therefore, it is expected out of the judiciary that the task of statutory interpretation is performed with utmost care and caution. Therefore, the courts are under a sole discretion to interpret the statutes on its own in an appropriate way so that justice is rendered to the people. So interpretation of each of these provision, interpretation of each of these statute to bring them harmoniously, to construct them harmoniously and reconcile them together is a task that is quite important and quite needs to be established. So there has to be very clear specific provision and to make it more unambiguous to the people, the general public in viewance of it. Thank you.